permitted to mention one matter for withdrawal, my lord.
For
For withdrawal, my lord.
inclusion
No, for withdrawal, my lord.
Lordship,
to be mentioned.
Lordship, may I be permitted to mention one matter for inclusion?
Give it.
My lord, we had filed 6 back, my lord, before and it was supposed to appear in the court 8. Court 8. Thereafter, my lord, the determination changed and now the files are lying in SR department, my lord. We were expecting that the matter will come up in the serial list without mentioning. But yesterday when I came and I came to know that I have to mention it, my lord, kindly.
Give the numbers.
My lord, I've got everything, my lord.
Give the numbers.
My lord.
Get the files. Call the list.
Item number 1.
My lord, I beg to appear for the petition.
Why it has come to be mentioned?
Lord,
Lordship, in this matter, Lordship, on behalf of the state, I am praying for a very short password.
Why it has come to be mentioned?
my lord, this is a matter which was set for mediation, my lord. Lordship wanted to see the mediation report previous occasion.
Let him be here since he should. Not today. Not today. No.
Monday of it.
Item number 2.
Not today. The direct.
Oh.
Item number 2 was adjourned yesterday.
Yes, we remember.
By ascertaining the dates.
Should have instructions that the recruitment process is ongoing. However, it is in the last stage, which is the detailed medical examination stage.
9th is the last date that I have, my lord.
9th.
9th of December. Now, my learned friend will be in a better position.
He is saying detailed medical examination is
Going on. 9th is the last date.
And where is this? Where is he supposed to appear?
My lord, that now since my lord the appellate court is not there, so my lord now the central office will determine, that is in Delhi.
Why appellate board is not there?
Because my lord the appellate part is over. The appeal has to be, my lord, preferred within that period of time.
No.
If your lordship goes into the, my lord, order that was passed by the honorable single judge, your lordship will find that that has been directed to go before Delhi.
Let us.
That is the page 42.
There is nothing. It's just for availing the remedy of appeal.
Yes, appeal. But Lordship, my lord, this is my respectful submission. If your Lordship goes into the, my lord, that appellate provision, it says that the appeal has to be preferred within a day. And
That
anyway,
is
my
all
lord, I
right.
will not make any further submissions.
That is all right,
Yes.
but the honorable single judge has said that
Go
you
before the appellate.
go before the appellate forum within 3 days.
Yes.
So where is the appellate forum?
The appellate forum is in Durgapur.
What do you want?
My lord, I will make no further submissions. If your Lordship is kind enough to, my lord, grant me another 3 days, I will make no further submissions. I'm not in a position to make any further submissions.
After
ফ্রাইডে ফ্রাইডের মধ্যেও অ্যাপিলে ইয়ে করবে আমাদের আর কিছু নেই আমাদের আর কিছু নেই
Extremely grateful, my lord.
Item number 3,
same on.
item number 4,
4, I am for the petitioner. The matter relates to, well, on 6th, kindly
2009 matter.
come to the order dated 16 June 2023. There is a direction upon the Chief Secretary to hear out the issue. And
Oh, that matter. What happened?
now, well, 2 years, already 2.5 years have been elapsed. Now, extension, they formed a committee, extension.
Yesterday, matter was going to be placed before the cabinet for approval. Just technical defects were returned. The next cabinet, you can't give me a
Next means
3 weeks. Normally 2 to 3 weeks. Cabinet.
Next means, my lord, because, my lord, the matter is appeared today. There
what
is a
do you want?
direction.
What do you want?
Kindly see, my lord, my CAN application where there is a direction, my lord, for where,
No, therefore we are saying, what do you want?
well, let them, my lord, as early as
As to-
decide the issue. We have
Yes. Yes. You are for? But that is already, there is an order for them to take a decision.
Already recommendation has been made. Just approval of the cabinet is necessary. Yesterday, the meeting was, file was going to be placed before the cabinet. Technical defects was still, file was returned. On our next cabinet, it will be placed, kindly adjourned for 3 weeks. In the meantime, we will notify.
Yes. And
court also to carry such old matters, stale matters. It looks very bad. Hearing a 2009 matter in 25.
Now in 9 read petition. Kindly.
When you go, you can send it.
Item number 5,
Madam for the petition. This also. This matter, my lord, pertains to, my lord, the denial of my prayer for consideration of regularization. This circle. In the my lord, DDT spray. Yes, that one.
Oh, they are seasonal workers.
They are seasonal workers. That is the ground for which I am rejected. So, my lord, I have, my lord, only 4 documents to place before your lordship. If I'm there, otherwise not. So, my lord,
This is under a World Bank project,
but,
something like that.
previously, my lord, this was under that, but seeing the, my lord, continuation of that, my lord, thereafter NMEP project of the central government has come, and they have been working under that as well. Be that as it may, my lord. My lord, just
They are omnipresent. Even in Bihar, there were so many cases of this DDT spray.
my lord, because, my lord, this vectors are omnipresent, my lord, the mosquitoes.
Yes, yes.
So I just tell you, lordship, my lord, what happens here. My lord, initially, my lord, this issue, my lord, has cropped up before this honorable court, my lord, whether these incumbents in other district, whether they could be regularized or not. So in 2001, my lord, the honorable division bench of this honorable court has held that yes, seeing the nature of this DDT spray workers and everyone of that particular district, they are required to be regularized and directed to be regularized. So after that, my lord, what happened? My lord, that order, my lord, was circulated entirely, my lord, throughout the state. My lord, seeing that particular order, my lord, the decision has been taken by the government of West Bengal for, my lord, regularizing those DDT workers who have been working then at that particular time. So, my lord, in 2008, my lord, they issued a notification where, my lord, the names of different persons were given. Petitioner's name were also there. Where, my lord, it was said that this individual are directed to be regularized and will be accordingly regularized them. That was the direction of the DHS, my lord, Director of Health
So
Services.
this was in compliance of some order of the writ court.
My lord, these incumbents did not approach, but, my lord, the honorable after the order of the honorable court, the government of West Bengal issued the notification by saying that we have got this order in.
So rather than confining it to a district, they made a holistic view of the matter and all the persons were examined.
Great. That is the case.
That is what you are making.
Yes, I'm sorry. Yes. So after that, my lord, what happens, my lord? My name transpired there. Though, my lord, there are 8 petitioners, 2 persons' name transpired, not the entire 6. The other 6.
Item number
So
4.
after that, my lord, nothing happened. In 2015, again, the government of West Bengal, my lord, wanted to have the list of those persons who have been working on that, my lord. And there, my lord, the list was forwarded by the CMOH of our particular district, where, my lord, the name of these persons, all of those persons are, my lord, prevalent. After that, my lord, nothing happened. We went.
So in the 15 list, you all are figuring.
We have been working till today.
No, in the 15 list, all the petitioners'
All the
name
petitioners-
appear.
Yes. All of them's name are there. After that, my lord,
So if
nothing
you are not there in 8, how you can be there in 15?
But at that particular time, some of the persons did not complete 10 years in 2008.
So 15 again, they examined whether 10 years was complete or not.
So then, my lord, the incumbents, those persons' name were there. So, my lord, we made representation that what happened to this. My lord, that was not considered. We went before the learned tribunal. The learned tribunal passed this order immediately. Where, my lord, one line, my lord, it has been said, nature of the duty says that you are seasonal, but it cannot be considered.
So let us see the 2 recommendations of 2008 and 15.
Great. Would your lordship, my lord, be pleasure, my lord, to see the honorable court's order once before that?
Based on which 2008, you can show it, yes.
But if I request your lordship to see, my lord, page number 136. If these 3 documents, I'll show your lordship. The honorable court's order at page number 136. And my lord, the memo. I'm sorry. But, it starts from 136. If I could show your lordship the relevant part, but I know my lord will be seeing my lord the entire. But if I request your lordship to see my lord the relevant part once. But,
Yes.
So after this, my lord. After this, my lord, your lordship kindly sees page number 104. It is, my lord, the notification of, my lord, 19th of November 20.
So what did the division bench direct for the writ petitioners?
Those writ petitioners, my lord, that was lordship has already seen that these are continuation of the proceeding. My lord, those persons, my lord, were
Actually, the only issue was whether 100% or 50% of the vacancies is to
Were
be
there-
made available or not.
and whether the age bar would be
Age bar would apply. So these
it was said that no, it won't be applicable, and there won't be, my lord, any percentage of the reservation for these persons. So after that, my lord, 2008, my lord, kindly sees page number 104 once. Kindly, my lord, excuse me, my lord, there are, my lord, two page numbers. So if I request your lordships, my lord, to see the page numbers which is at the top.
not 66.
No.
Not 66.
66, my lord, it has to be, it was required to be cut. So kindly sees, yes, that one. But here, my lord, the reference of this WPST has been given. This order.
What does it say? The candidates mentioned in the next list of the respective
Of the respective, my lord, respective
districts are found eligible, perhaps. The respective districts are found, that is eligible,
yes, my lord.
maybe, hopefully. Yes,
So, my lord, this is the document lordship has seen. Now, my lord, page number 10, the next to the next page. Page number 106. So, my lord, that would be the list of spray workers eligible for absorption in Group D post, District Purulia. So, there your lordship will find two of the petitioners' name at serial number 137 and 188. Which would be, my lord, at page number 108 and 109. 137, Yakub Ansari. And your lordship will see the date of joining.
they are petitioner numbers.
Yakub Ansari is petition number 1.
Yes.
And lordship will see, kindly transfer the next page. Last but one name, Kalipodo Mahato.
Petitioner number.
Last petitioner, my lord. Petition number 8. That's it. Kalipodo Mahato. But I'm sorry, my lord. That is not a petition. So only one petitioner's name is there, which is page number, because that is Kalipodo Kumar, not Mahato. So it is page number 108 only. Yakub Ansari.
So Kalipada was not a petitioner.
Not petitioner, because that is Kumar. That was Mahato. My wrong submission before you.
Yes.
So, my lord, after this, my lord, I'll just request your lordship, my lord, to see Page number 93 once. But, as your lordship saw, is a format that has been supplied to all the CMOHs, especially here, my lord, to the CMOH Purulia. May I place, my lord? In pursuance to memo number 21st April 2015 issued by the Principal Secretary, Finance Department, Government of West Bengal, you are requested to please furnish the report immediately through email ID regarding number of daily rated contractual casual workers who have remained engaged more than 10 years or less separately for each category in the prescribed pro forma given below. On the next page, the CMOH Purulia forwards it to the Joint Director of the Personnel. 22nd June 2015. The list.
You are at 28.
Yes, my lord. Yes. George. Yes, my lord. Serial number 28.
Yes.
Then, my lord, the others are 97.
Serial 97.
Serial number 97.
Yes.
Serial number 99.
99.
Serial number 101.
Yes.
103.
Yes.
105. 108.
So 7.
I must be candid to your lordship. Last one, the person who is in 111.
Yes.
Lordship will see the remark that he did not complete 10 years.
But he is a petitioner here.
The petition.
Petition number
8. So, my lord, after this, my lord, I made several representations. We had, my lord, a union as well. Separately, with union, several representations were made and were forwarded by the CMOH to the authorities. And, my lord, nothing was being done. But for which, my lord, we preferred this original application before the learned trial. If I request your lordship to see the prayer in my original application. My lord, original application starts at page number 36. My lord, the prayers your lordship will find at page number 59. My lord, all I prayed, my lord, here for absorption and also consideration for absorption for working for more than 10 years.
Yes.
My lord, last I request your lordship to see, my lord, the order impugned, which is 25th April 2024. Last
25th February.
25th April 2024. One of the last but 2 pages of the writ petition. So my only submission before your lordship is that this finding of the learned tribe, that only because of the reason that they are seasonal workers, they cannot be even considered, is, my lord, wrong.
They filed a reply before the tribunal.
My lord, they did not. They did not. There was no opportunity that was given.
Before this court, were they allowed
Yes,
any?
yes, yes. They have preferred a reply.
They
Sorry,
filed opposition.
So, my lord, in the opposition, what you can see how they have my abandonment in the writ petition. Before that, I take your lordship. My lord, if I request your lordship, my lord, to see page number 10 of my writ petition.
Yes.
But paragraph number E, my lord, is the ground that I have taken here. Not ground, but the fact that I placed. And also, my lord, I is on the next page. Now, my lord, I'm sorry. In the opposite, if I just can take your lordship.
Yes.
But in the opposition, but page number 8, their opposition. Paragraph number 9, last paragraph. In response to the joint.
No, when you say in paragraph E
Yes.
that 120 employees have been found eligible for absorption, where is that? We don't find it in the 2015 document. It does not even talk about
does it-
any absorption or regularization.
It only says that only 10 years of experienced person can
Some authority has asked them to forward, they have forwarded that who have completed 10 years.
right, man. Yes.
Now, within these 10 years, how many number of working days and all that, we don't know. That's not there.
But only one of their calculation about this perspective that yes, I have been working continuously for 10 years. This is their recommendation. So I just said that my case could have been considered on the basis.
It does not say continuously also. That is the problem. It says 10 years you have been working.
Subject to
Now,
correction.
10 years, whether it is intermittent or permanent or how many days in a year, there is nothing about that. It does not even talk about the number of days.
Yes, my lord. But it says continuous service of 10 years.
No, continuous, it does not say anywhere.
The lordship analysis, the page number that I was referring to, my lord.
Yes. Can you find the word continuous anywhere?
Just take the right to take your lordship. Page number 93 is the first.
So where does it say continuous?
It says that engaged for more than 10 years. Yes.
It does not say continuous.
Yes.
Whether it is in continuity, whether it is intermittently, how many days in a year, in a month, we don't know.
My lord, my respectful submission before your lordship would be, my lord, they unless my lord they say that they are not continue, they are not continuous or my
Like
lord,
you have to make out a case, then only you have not made out a case. You say I have only 10 years existence in the department. How many number of working days, nobody knows. So was any order passed on your claim by the authorities?
No, this is why I approached before the learned tribe.
Where after making a representation?
Yes, yes.
Where is that representation?
But that there are several. I'll just take your lordship to some. my lord, fast I see, my lord, page number 72, my lord. It is a, oh, sorry. It's, I'm sorry, I cannot, my lord, place reliance on that. Wait a minute. 1 second, man. If I request you, lordship, see, my lord, page number 118.
Not a prayer for regularization.
My lord, this is one of the representation which is in English, my lord. I
But
guess.
this representation, you admit that you are not working regularly. You say give us regular work, and you say that throughout the year.
I have, my lord, some of the representations which I only
Does not lay the premise for a claim to regularization based on a continuous service of 10 years against a sanctioned post or anything like that.
at page number 112 and 113 as the representation written in Bengali. If I just can place, my lord, one paragraph of that by translating.
112.
It's 113, 112 and 113. If I just can place, my lord, the last paragraph of that, trying to translate it in English. Last paragraph. However, it's my request to the on behalf of this union, DDT Spray Workers Union,
113.
this year in 2019, so that we get the excess remuneration and also appoint us immediately in permanent employment, for which we will be grateful.
Yes. There is no case made out that you have been working on a daily basis regularly. You are more interested in getting the benefits of some kind of security of tenure because the government has a scheme of that kind also. Apparently, but that is why you're writing.
My submission before your lordship is, my lord,
So even if you say so, that is not corroborated by the 2015 document. It does not certify a continuous work for 10 years.
It does. It only says that I have been working for 10 years.
10 years.
Now, my lord, if your lordship sees there, your lordship, there is a mentioning of one memo.
And
was trying to
you have to appreciate that every candidate will have to make out individually that he is working for 10 years without any aid of an order of a court against a sanctioned post, and that his initial induction was in accordance with law, because the judgments you are relying upon are all prior to 2006. You very well know that in that judgment in 2006, it says all earlier judgments shall stand denuded of their effect. So therefore, the rigors which you have now to fulfill are the rigors laid down in those specific paragraphs in 2006 1 SCC.
Yes.
Where is the material?
But,
How a direction can be issued?
I was trying to find out, my lord, there was a mentioning of memo, if your lordship kindly sees, at page number, my lord, 93.
Yes,
So that letter, which I first referred in 2015,
yes.
my lord, it says that in pursuant to the memo number such as
Yes,
that,
21-4, we have seen that. 21-4-15,
yes, that one.
yes.
That memorandum I tried to search out, my lord. My client say that this is the memo which, my lord, it is kind of a scheme that was framed after the Uma Devis by the state of West Bengal, but I could not find it out. So I cannot. It says that 21st April 2015, Principal Secretary Finance requested to please furnish immediately through such and such. Again, number of delegated contractual casual remained engaged for 10 years or less. So, my submission before before the learned tribunal was that this factual aspect considered by the authority. That's one of the authority. My prima facie case before the learned tribunal was that my name, as I have been working for 10 years, but it is there by their document itself. They could have considered my case. But the learned tribunal went on saying that since they are seasonal worker, cannot be considered.
Therefore, the point is either you have a
And even, my lord, in the opposition also, if your lord
enforceable claim or you don't. Unless you are able to make out an enforceable claim, either the tribunal or the writ court, how it can issue a direction.
the tribunal, my lord, could have, my lord, at least, because, my lord, I tell your lordship, because by showing this particular document prima facie, it could be established unless something contrary.
Correct. So it can establish what it says,
Yes.
not beyond that. It does not say continuous.
My lord,
There's
it
not
does-
even a whisper about continuous work or having fulfilled to 40 days in a year or anything of that kind. It certifies at best existence of 7 of you in the department for the last 10 years. 8th person's existence is also not certified.
Yes.
So on that basis, can a direction be issued as prayed for in the OA?
But by placing that particular document on record, my lord, I tried to say that pursuant to that particular memorandum, my lord, my case was being considered. Since it was not being considered, my lord, kindly direct them to consider. That was my prayer. So my lord, I just said that even in their opposition, because if they could have used the reply before the learned tribunal, things could have been more, my lord, manifest. So, my lord, here in the opposition, my lord, in paragraph number 8, they, my lord, do not, my lord, only say that it is a statement of the.
We did not see the opposition. What is there in the opposition?
Page number 8, paragraph number 9, where, my lord, they have dealt with that particular paragraph of mine, my lord, of the writ petition. In response, the second paragraph. In response to the letter of joint director dated such and such, the 86 number of delegated
You
workers.
see the last line of para 9, that is precisely their case, what we are observing.
Yes, I was taking your lordship to that on. But delegated workers completed 10 years of service on 1st of April 2015, but it is
Merely a statement about number of daily rated workers engaged from time to time, but not about perennial type of workers. So there is nothing there that
they never say that I did not work for that my work is not perennial.
see there is a statement made in your way. In support of that statement, you are relying on a document. The document itself does not show that there is a perennial engagement or that you have been continuously employed for 10 years. So what is there?
This is one.
Unless you make out a case, how they can counter that?
Paragraph number 11 also, my lord, that 2008, where, my lord, the petitioner number 1's case was, my lord, mentioned.
May have been, but you see that 2008 recommendation says strictly as per seniority. We don't know. Maybe above you, others were
No,
absorbed.
It is said that.
But
they
that
have-
2008 thing is over. That exercise is over. Now 2015 exercise afresh.
2008, my lord, there is a direction of me being appointed.
No, 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 no. That's not the case. It is a list of persons employed and it says as per seniority, they will be absorbed.
Yes.
You are at a particular seniority. Maybe 10 persons, up to 10 persons above you, they have been absorbed. After that, there was no vacancy.
That was never anyone's case.
But you never agitated after 2008.
But I have been, yes, sir, that particular gentleman has been making representation, but I
Can keep making representations. After 2008, it did nothing because obviously then it leads to a presumption that exercise is over. In 15, there is another exercise undertaken by the authorities that you forward names of persons in the department for 10 years. In that, again, his name comes.
In that event, my lord, department has that proceeding which they have initiated. They are under the obligation, my lord, of this.
What has been initiated? That's what we are saying. This 2015 does not talk about regularization.
My lord,
It only says send a list of the persons working for 10 years. For what purpose? Maybe they want to put an embargo that now nobody else will be appointed. We don't know what is the purpose. There are so many issues that can arise from that. It does not appear that it is part of an exercise to appoint or regularize.
Follow your lordship's point.
So therefore, we cannot.
Only my lord,
Therefore, the tribunal could not have given a direction.
I just say, your lordship appreciate this, that this gentleman, these persons, my lord, have been, my lord, working for long time. After that, my lord, their names were called upon by the department and the CMO is, my lord, for by a particular notification. Now, problem is this, my lord, none of us are having this notification right now before us. My lord, if the state could have, my lord, at least placed in their opposition that this is the notification, it doesn't say about regularization. That also, my lord, they did not. So, my lord, now what happens, my lord? They quote a notification and say that provide the names of 10 years of experience, person, service, and everything. But if after that, my lord, nothing happened, we wanted to know the fate. So that, my lord, our names could be, since our names were forwarded, what are the fate of that?
The petitioner has to make out his own case. That will not be made out by the department.
But
You are relying upon a document. Everybody knows how to get these documents. And such persons who have been litigating for decades, they can't say that we don't know.
But that document I also could not find in the internet of 2015.
That's why we are saying there are so many ways of getting these documents. We all know.
But in the opposition, because I was, my lord, very much relying upon their opposition, they did not even say that this was not a.
Cannot. That's why we are saying for you to make out your case. You have to make out a case that, look, I was appointed on such and such day. I have continued to work. I have worked for such and such number. And then if that document supports that contention, then it is for them to say why they are not regularizing it. Your document itself does not support the contention. You say that I have been working perennially, but the document does not support that.
But that is the only one official communication that was made on our behalf. And we were, my lord, expecting the state, my lord, to act on this.
Plus, your representation shows that you are not working perennially. It says that please give us continuous work, and it says that please give us a fixed salary.
There are other representations which I.
So which one is to apply to which petitioner? That's what we are saying. How a direction can be given?
But there are, my lord, number.
And all are by a leader.
My lord, all of the persons, my lord, put their signatures. Lord, you will see that.
Maybe.
In Bengali, my lord, there is a problem.
That one I cannot read. I am relying on the English one. I cannot read the
That
Bengali.
I followed your lordship. But I have award in my original application also, my lord. If I just put, my lord, place your lordship.
That's why we have read that. That's why we are saying you make out a case in the OA, but that's not supported by the documents. That's not supported by your own representation.
But if I just can, my lord, translate this representation, my lord, page number 113 to 117. And my lord, come to your lordship's back. Yes, sir.
When did you file the OA?
But I filed this original application already in July 2024.
So for 9 years you are representing.
But yes. And my lord, see the persons of this petition number 1. But his name was said to be, my lord, forwarded and everything. Even in spite of that, my lord, nothing happened. And they see the date of, my lord, his engagement back in 1991.
You don't know.
That is from their document. 2008 list.
Hmm.
What are the observation of the learned? I'm sorry.
Not 91, 2001.
No, my lord, 2008 circular, it says 103. Page
Come to
number.
page 95.
My lord, that is one subsequent.
Yes, that you are relying on this.
That is
Date of
subsequent.
engagement is 2001.
My lord, that it says here. Lordship has seen in page number 1081. It is of 2000.
That is over. That's over. You never made any claim in respect of that. Now this is the only document.
But my right was accrued at that particular time. Lordship will see page number, the wording of page number 108. But anyways, Mala, I did not get that. The fact remains that I did not. But, I was just referring to your Lordship, my lord, the learned tribunal's order. My lord, the reasoning of the learned tribunal was, since they are seasonal worker, the question of absorption cannot arise.
So what that's why we are saying, where is the material to say that you are not seasonal, you have been continuously engaged.
We are, my lord, seasonal worker. All I was saying that seasonal workers can also be, my lord, regularized, as has been held by this honorable court on the earlier rounds of litigations. It cannot be said, well, or only because of the reason that I'm a seasonal, I cannot even be regularized. That is a wrong, subject to correction, my lord, is a wrong observation of the law. Because if our case could have been considered, we strictly believe, my lord, that since we know that we have been working since long, we could have been, my lord, given this.
It's a rather stale claim also.
My lord, it is my respectful submission before your lordship, my lord. It is I have been still working.
Will be opening a floodgate unnecessarily at this belated stage.
But I have been working on it since then till today, and my lord, it is my continuous cause of action, my lord. I just take your lordship to that, because this, unless do the regularization, the honorable lordship's earlier occasion and the honorable Supreme Court said that the regularization could be said to be a continuous cause of action.
There's not a single document to show that you are continuously working. That is the biggest problem.
But, apart from this,
Apart from averments, there is nothing. And that also now 15 recommendation, nobody knows what happened. In 24, you are waking from your slumber
they could have
after 9 years.
that could have been, my lord. If they could have said that no, they are not continuous and everything, that would have, my lord, made the entire things, my lord, could have.
In their opposition, they have said in a way.
They only say that the government says this recommendation of CMO, it doesn't say that you are continuous.
Yes. Let us see. Yes, what is your stand in the opposition?
Mr. Amitullah Chatterjee arguing one matter in courtroom number 30, Your Lordship. Uh, uh, we will conclude our portion, Your Lordship. Kindly give us a password, Your Lordship.
This is the way you are sitting here without telling the court anything.
Lordship,
As if
he started the argument.
you are not here, then what he should do? Yesterday also you got an adjournment in this matter. Every day it is to be adjourned.
No, Your Lordship. Kindly.
When ask him to come?
Yes, Your Lordship. Kindly for password.
Casual adjournments, just for the asking.
may I seek leave to bring
They have specifically set 180 days maximum. There are 2 times in a year when you are engaged or when that need arises, and maximum 180 days a year. They have set.
Paragraph number 7.
Yes.
But they admitted 2 times and they never wanted to say that I was not continuous for 180 days or 40 days.
Engaged for maximum 180 days in a year.
Yes. Yes, my lord.
Maximum.
What you can see is that 7 except for the matter of records, rest it is specifically mentioned that spray worker engaged of the indoor rescue or such and such 2 rounds in a year, a seasonal delivery, the operational area of such and such area is a district of such and such.
No, come to page para 15. 2 times a year, and then how many days is there in para 15? Totaling maximum of 180 days in a year.
Yes.
So as per need, you are being engaged. And that is the maximum 180 days in a year.
Thing, my lord, with this 1996 notification which says that 180 days is deferred. My lord, one kindly see, my lord, I have annexed 1996. There is a
Point is, even if we accept that you are working 180 days and twice in a year you are engaged, will that make it a perennial nature of work? That will not make it a perennial.
This, my lord, has been taken care of by the Honorable Court in the earlier litigation.
Yes, maybe. Maybe.
These are DDT spray workers because they have, my lord, seen the nature of our work and service. And it is so perennial, my lord, that it is still today it's required. Could not be eradicated by any means. My lord, by my lord, observing that, my lord, the DDT spray workers itself, my lord, they have got the, my lord, benefit of being regularized on the earlier times.
Who has been regularized?
My lord, the persons in 2008, sir.
Who? Give one example of one person who has been regularized.
My lord, the names.
Where are the names?
Number in 2008 circular.
There are no regularization. This carrying of names saying that if vacancy is available, absorb them and absorb them as per seniority.
But if I
that is all. There is no regularization.
It is I just 1 second, my lord, place that once last and thereafter, my lord, you will hear my land senior. My lord, kindly sees page number 104 last for the last time, my lord, once. Yeah. I will place that. It says that since the Honorable Supreme Court dismissed the SNC such and such, WP number such and such, and in compliance with such and such WPST by their lordships arising out of common judgment of such and such, and on scrutiny of the list furnished by CMOHs of different districts regarding the eligible candidates amongst DDT spray workers for absorption of Group D post, the candidates mentioned in the annex list of the respective district are found eligible having fulfilled the criteria for absorption.
So from this list, there is only one person. There is only one person. Yes, now.
Accordingly, the CMOHs of concerned districts are directed to absorb them to the existing vacancies.
Correct. Now that is what we are saying. Please read that entire.
Vacancies of the such and such districts by maintaining the
Seniority
in strict order.
Strict order.
That is
So
the
why
first
you have
intent.
missed? You are below seniority, or why not? That you never raised. In 2008, it was done. You have slept over it now for more than a decade.
But after this, my lord, we have been, my lord, lordship kindly appreciate
Not
the
we.
action
There is only one person under this letter.
Yes,
There is no
somebody
question of under this letter. There is no question of we.
No, we.
Under this
So
question
only
letter,
we-
there is only one person. He has done nothing
But,
till 2024 from 2008
this letter, my
for
lord, itself
15
shows
years.
that this person's, my lord, is
All right,
entitled.
this will consider.
And after that, my lord, the 2015 and the scope of regularization after, my lord, being they took a point in opposition, my lord, that after 1991 nobody can be engaged. My lord, that is the law point, my lord, they have taken.
We don't know about petitioner number 1. He has not said anything why he was not engaged pursuant to
No, my lord, the notification of government of West Bengal, it says that after they say that,
No, after this 1911-2008,
yes,
petitioner number 1 does not say why he was not engaged or why he was not absorbed. What steps he took? There is nothing. He is just sitting idle for 15-16 years.
but
And then approaching the court by the tribunal by an OA filed in 24
after this, my lord,
with 7 more persons.
that I will be, my lord, if this particular incumbents about this incumbents, my lord, stand about this, my lord, I cannot specifically, my lord, address your lords.
But unless case is made out,
My case only right now before your lordship was of 2015 since the state wanted the names, and what did the state do after this one? And we have been working since long, my lord. If we could be, our case only could be considered by the department. Then, my lord, they say whatever they want to.
That we are not stopping. You want to go, we will not stop you. We will not give a mandate for this now. It will be opening our stale claim.
So I cannot even pray right now before your lordship because I did not even, my lord, say before the learned tribunal that I said in my pleading, of course. But my lord, my prayer before their lordships, before the learned tribunal were also, my lord, that so that our case could be considered only. If the department or considers our case, if they say that we did not, then we can, my lord, place on record, my lord, the evidences that we did.
If you want to go again, we are saying we are not stopping.
Because
We are not going to direct.
Our case was never considered.
That you have said. That you have said. Again, we are saying if you want to go, we will permit you. But we are not going to give a mandate.
No, my lord, I do not seek because I will not pray before your lordship that also. All I pray before your lordship because they all the records of our cases, my lord, are lying with the department.
What lying, sir?
They-
20-year record. Now you want them to find out.
We have been continuously working.
Nobody, apart from petitioner number one, nobody in this writ petition can say he has been continuously working.
And, we stated on affidavit if they could have replied to that, my lord, also.
Please try to understand your case.
Yes,
You may say whatever you want on affidavit, but the document does not support your case. Your own documents don't support your case.
My lord, only, my lord, that document only this I could place before your lordship. That this 2015 they wanted our names, but we do not know what did they do after.
We do not know why they compiled it all.
This is all my submission.
Yes.
Our case could have been considered. But if I could take your lordship leave, if I just could take your lordship leave, man.
Yes, yes.
Lordship, first of all, I tender my unqualified apology. I am the court.
Every day.
I am in the court.
Yesterday also and today also.
My lord, I am.
What is this?
Sorry, my lord, I am.
Yes, please proceed.
First of all, I place my affidavit in opposition filed by the respondent, my lord. Page 8, my lord.
Page
8, my
of your opposition.
opposition. Para 9, my lord. In reference to the statement made in paragraph 3 of A of the application, that is the second one. In response of the latest Joint Director, Personal CMH, Purulia by his letter dated 22nd June 2015 said intimated that 86 number of daily rated workers. My lord, that the daily rated workers and that the seasonal workers, my lord. DDT spray workers completed 10 years of service as 1st April 2015. But it is merely a statement of CMH, my lord. But it is a departmental communications and there's the information sought for by the department, my lord. Engaged from the time to time, but not about the perennial type of workers, my lord. But their right are not vested as a right of permanent work, my lord, is a seasonal worker regarding the during the time of malaria, my lord, and the dengue, they're for they're the spray workers, my lord. For the eradication of dengue and malaria, my lord, on the seasonal basis, then on a contractual service, my lord, they work, my lord. Para 11, my lord. With reference to the allegations made in para 3I of J of the application 7, except for the matter of records, I specifically admit in the rest of the government, I say that mother consonance with the Labor Department memo such and such 13 March 1996, it has been mentioned all such workers, including seasonal workers, engage in perennial type of works in any establishment under the various department of government, except the Home Department, including Home and Transport Department, includes Reconciliation Department during the period of 4/8/79 to 31st December 1991, still continuing to be engaged, maybe absorbed on temporary basis. On the temporary basis in any regular establishment on the state government subject to the fulfillment of other criteria My lord, there's specifically mentioned the other terms and conditions laid down by the labor department's memo. In annexure. And my lord, the specific criteria is specifically mentioned in memorandum 100 EMP 1M, that is annexed with my
Annexure E.
annexure E, my lord.
What is the page?
কালকে
21.
21, my lord. The principle of the following in the matter of the absorptions and casual and such others categories of workers of discontinuations of the further engagement thereof under the government of West Bengal, the principle to the followed in the matter of absorptions of the casual and others categories of the workers engaged up to 379 in the regular establishment of the government and also of discontinuation of engagement of such workers beyond 3rd June 79, where earlier declared by the government of embodied in the labor department's earlier memo, such and such principles of the engagement of such workers on exceptional cases was also explained in the labor department said memo. Government decisions, prohibitions on further engagement of such workers was retained from the time to time, ending with the labor department memo 401 EMP dated 8 December 1991. In spite of that, it was brought to the notice of the government that some department recommended to engagement of such workers even after 3rd August 79 from some essential workers. My lord, these memos not yet, they are not fulfilled this memo, my lord. All such workers, my last, all such workers, including seasonal workers, engagement in perennial type of work in establishment under the various establishment of government, excepting the Home Department and Transport Department. That was, my lord, specifically mentioned in my opposition, my lord.
Which paragraph? No, from this notification that you are reading.
Yeah,
This, what is the number?
my lord.
13,396
13.
memorandum. Which paragraph you are relying?
All such workers, my lord. Second paragraph, my lord. Asked of the question of the absorption on casual and other categories of workers engagement in such from time to time and the various establishment under the government of West Bengal and regular establishment and also the question of reiterating the engagement have been under active consideration of the government and after careful
No, they are relying upon the.
Third one, my lord. All the workers, including seasonal workers, engagement.
Please see 104, page 104 of the writ petition.
Establishment under the various department of government. Since the Honorable Supreme Court, my lord, Lordship's places, my lord, 104, page 66 of the.
Page 104, 66, yes, one and the same.
The Honorable Supreme Court of India, SLP, such and such dismissed, my lord, such and such case number, and order dated 10th. Arising out to some justice. Hard list. Group D of the post of the candidate mentioned in the pay workers eligibility having fulfilled the criteria of the absorptions accordingly CMH concerned district are directed to absorb the existing vacancies and described by the fulfill the criteria, specifically mention the fulfill the criteria, other criteria. specifically mention the fulfill the other criteria, my lord. Accordingly, CMH is concerned directed, CMH concerned district are directed to absorb them to the existing vacancies in the district by maintaining the seniority in selected others. Contract will go get fast appointments after absorption for the necessary formalities in maintaining the 100 point rosters, except the age beyond 45 years. No bar on such absorption. My lord.
No, in this, they have an extra list, which you say is the list of eligible candidates. And petitioner number 1 is at serial 137.
I think petitioner number 1 is concerned, is in item number 137. My lord.
Yes. Then what happened after that exercise? What happened? Why he was not regularized? Is there anything?
Regarding the seasonal worker is concerned, my lord, we are not in continuous service on the period of 180 days, my lord. But they are the eligible, my lord, but other terms is concerned, my lord, we are not made suitable for him to absorb, my lord.
1911, 2008. This 1911, 2008 document, was it part of the OA? Yes. Yes, annexure J. Annexure J. Get down at 12. Yes, that's all. Anything else? Yes, take down. Heard the learned advocate.
The matter. I'm contesting the elections, my lord, as a candidate. So
Today?
Election is continuing since yesterday.
Oh,
It will continue
for
tomorrow
which association?
for our High Court club,
Oh.
my lord, under compelling
So
circumstances.
not today will suffice. It will come on Monday.
Monday.
Yes,
Because it's entire 6 and 7 both, your lordship.
not today.
Much of not this week, my lords.
See, on Monday and Tuesday we are taking up WPST. So on Tuesday, not today means it will come on Monday.
On next Monday.
Monday.
Monday, the monthly list will be there. The matter will be fairly at the top position, my lord. Much obliged, your lordships.
Item number 8.
At last occasion, my lord directed to find out the judgment. And Mr. Mukherjee found out morning he was showing me, and I have also found out another judgment passed by my lord. My lord, may I?
One person submitted. No action was. Then somebody else will come in. Please submit. Think you are very important. Yes.
Not today.
That was crossed by that was the well purchase.
Yes, in your case, when the first application was filed,
First application.
what is the date of death?
Date of death, my lord, 16 July 2013.
And first application?
First application on August 2013. I'm telling the date.
By whom?
By the husband, by the father of the petitioner.
Give the date, please. Reply was filed in the tribunal. No. Then you file the opposition. We are giving you one opportunity. Let him file an opposition.
Liberty may be given to file a
Or-
reply if yes,
For filing of opposition, can it be parted?
but my lord, 3 days, my lord, had the matter.
No, we asked you to go through the judgment because you did not come with that judgment and we had passed the judgment earlier. Therefore, we asked you to go through that judgment.
My lord,
Yes.
this
23rd December. Item number 9.
None appears. None appears for the writ petitioner. Matter is adjourned for the
1st December. Item number 10.
There was a direction for the state to file an affidavit, my lord.
opposition.
Not opposition, lordship, by your lordship's order dated 25th of July. uh, Wanted the state to point out by filing affidavit how the petitioner is different from Pritam Ghoshal's case.
Not filed. By way of last indulgence.
16th December. Item number 11.
I am for the petitioner, my lord. I have to file the reply, my lord. The same is not ready, my lord. I am praying 2 weeks time, my lord.
As prayed by petitioners.
Item number 12.
Item number 12, my lord, matter on the last of the directed file the considered copy of the annexure. We have tendered our side told that we will accept. I do. So rejection by a lordship. Third one, my lord. The application filed by the
চলে আসছে বড় মাল রোড খুলে বিশাল রোড
You are for the respondent. The learned state council.
দু তারিখ মান্থলি লিস্ট
2 তারিখ 2nd December.
Item number 13.
Item number 13, I am for the petitioner. My lord, your lordship was from last occasion directed me to complete the service with regard to the, my lord, respond number, my lord, 6 is concerned. The service was completed. My lord, I obtained the tag report also, my lord. This is the, my lord, the item was delivered on 17th of November 2025.
You have filed it.
My lord, the video service and I obtained the tag report also. There is a direction by your lordship, my lord, on 18th of September 2025. You'll also can see the top, my lord. The item was, my lord, delivered on 17th of November 2025. And it was, my lord, sent on 7th of November 2025.
Not this week. Other hand will do. Not 2 days. This week. এটা দেখো না হ্যাঁ দেখতে পাই
Hmm. Relying on this item delivered, this is perhaps returned. It is. You place it on affidavit. There is no delivery. See where it has been delivered on 17/11.
The top malad delivered on malad on.
See where it has been delivered on 17/11. What is the destination? Yes, tell us.
Kolkata GPU.
She is living in Kolkata. Respond number 6.
No, my lord. He is the my lord, the applicant before the my lord, tribunal.
Yes.
At the address, my lord, that is at my lord. There is two address. One is Kharagpur, my lord, and another is my lord the Kotwali police station, Pusim Midnapur.
Respond number 6 in the present writ petition. What is her address?
There is a two address. One is in my lord, Matpur under Kharagpur police station.
Both are of Medinipur.
Both are Medinipur.
So Kolkata is Medinipur.
I should check my answer further.
You are expected to be more responsible.
Because often today, my lord, it's
So today only, therefore, without reading, you will tell the court that it is delivered.
on the top of the heading is there.
Very nice.
I shall my lord give a
Instead of expressing any remorse, you are trying to justify that you have irresponsibly made a statement. And we have to verify from these documents whether the lawyer is saying the correct thing or not. Very unfortunate.
top, my lord.
Till now, there is no
item number 14
Item 14, my lord, I appeal for the petitioner.
my lord the means of his argument that the inquiry proceeding was dropped by the inquiry authority because of supply of documents required by the, my lord, the employee concerned.
Oh, yes.
It was supposed to be, my lord, the service should be done. Yes. And my lord, after that, the inquiry authority said that because of non-supply of the documents, proceedings dropped. Now, at this juncture, my lord, if I say, because it was one line prayer practically, that I said that I have to go through the records because actually what happened, because otherwise I would not be able to place it. So my lord was, my lord, kind enough to give me time. Now, my lord, after having gone through the records, now, my lord, I have prepared a list of this. And my lord, I have already, my lord, handed over to your lordship on the last occasion. But instead of going through the same on the last occasion, it felt me our lordship that first a copy be handed over to him, let him go through, then let us come back. Now, my lord, it is the, my lord, the list of, my lordship kindly have it, that the, why this delay? My lord, initially, may I tell one thing, lordship? On the basis of the, my lord, the recommendation of the Vigilance Commission, the entire thing was taken up on the recommend. Lordship, kindly have it with the update of stop this habit of court. Where and handed over.
Yes, it's along with the judgment. No, all right. We have the list of dates.
Fine. Only, my lord, 3 pages list of dates. Lordship, kindly, my lord, come to the, my lord, first date, even 19th of July 2021. The Special Secretary, State Vigilance Commission, West Bengal, in writing of event date, mooted a proposal and or expressed its opinion that there are materials for proceeding against the writ petitioner departmentally under WBS CC and A Rule 71. Then the 4th April 2022, by memo number such and such of event date, the petitioner was served with articles of charges along with an intimation that an inquiry would be held under Rule 10 of West Bengal Services Classification, Control and Appeal Rule 78 against the writ petitioner. It should be 71. Then, my lord, 24th of August 2022, the additional Principal Chief Conservator of Forest and Chief Conservator of Forest Personal Management Cell of West Bengal informed, but that is the, my lord, the employer, informed the Deputy Secretary to the Government of West Bengal Department of Forest that the departmental proceeding after having been initiated against the petitioner, a formal request had been made to the State Vigilance Commission to hand over all relevant reports, documents and records in respect of which the charges were framed. The letter further contained that till date, the required documents were not supplied to the office of the Chief Conservator of Forest, the employer. Then November 13, 2024, again by memo number such and such of event date, the additional Principal Chief Conservator of Forest Human Resource Development requested the Commissioner for Departmental Inquiries and State Vigilance Commission to hand over the petitioner the documents referred to the Annexure 3 of the Articles of Charges. Then, Lordship, December 13, 2024, the Inquiry Authority, being Commissioner for Departmental Inquiry and Inquiring Authority State Vigilance Commission, passed an order of event date as communicated with a forwarding letter to the Additional Principal Chief Conservator of Forest Human Resource that in view of failure of the Department of Principal Chief Conservator of Forest to supply relevant documents to the charged officer, despite the fact that all those documents had been provided to the said department by the State Vigilance Commission, the departmental proceeding against the petitioner be dropped. Inquiring authority, when, my lord, came to that opinion, my lord, before that, my lord, the documents were not supplied, but he said that had been supplied, but still it was not supplied to the employee concerned. Then only after that, July 2, 2025, the Deputy Secretary, State Vigilance Commission, by memo number such and such of event date, forwarded the copy of documents as mentioned in Annexure 3 of Article of Charges in connection with the said departmental proceeding to the Additional Principal Chief Conservator of Forest, that is the, my lord, the disciplinary authority. Then July 14, by order number such and such of event date, then Press Inquiry Authority was appointed in place and stead of earlier one in connection with the pending departmental proceeding. His contention is that it cannot be again after having been dropped by the inquiring authority. Then, my lord, July 17, very important. The Additional Principal Chief Conservator of Forest, West Bengal, by memo number such and such of event date, forwarded all the documents, including annexure, to the charges to the present inquiring officer, as well as to the writ petitioner, being the charge officer. So eventually, after having been obtained in July 14, 2025, my lord, the again an inquiring authority was appointed, and my lord, all the papers those were supplied. So since initially there was vigilance, all the papers were vigilant, they were recommended for inquiry, departmental inquiry. We, my lord, set up the inquiring authority, but we failed to provide the papers because we could not collect the same from vigilance. Then the moment we, my lord, obtained the same, in my lord, we again, my lord, the inquiring authority start, my lord, the again set up and then.
So the document was with the authority who has dropped the proceeding.
No, the inquiring authority said that he sent his requisition for the documents to be supplied to the employee, but despite having been with the authority, they have not provided the same.
So where the documents were, it was with the Vigilance Commission.
Yes.
So that's why we are saying it was with the Vigilance Commission, and Vigilance Commission has dropped it because the document is not being.
Not dropped.
Who has dropped?
Vigilance recommended. That is why, my lord, the first date 19 July 2021. The vigilance expressed this opinion, the first date in my list of dates, that there are materials
On 13/12/24, what happened?
My lord, on 13/12/2024, the inquiry authority,
part of the vigilance,
but independent, not by the vigilance authority.
Okay.
Appointed by the disciplinary authority.
So the other day also I wanted to see what is the nature of this setup. I have not been able to see this Vigilance Commission.
My lord,
Your Lordship has asked me what is the procedure by which this proceeding can be taken up.
so far my knowledge goes.
There is some manual. There is some manual.
This is CCA rules under the Act. So for central vigilance, I know this is under
No,
the
CVC is central government
This
is.
my lord, way back in so far my knowledge. I also my lord, wanted some papers and they said they would be provided me. In 1965, by way of my lord administrative decision, the Vigilance Commission was my lord set up, and my lord they are to facilitate the initial the inquiry whether departmental proceeding would be taken up against any officer of the state of West Bengal or not. Then in 2012, the name of West Bengal Vigilance, the state vigilance, and some other modification was there. But the papers are not with me, but all my lord by
See, one primary issue that arises. I think it was in this case or maybe some other case
Yes,
that
yes.
the CCS under which the proceeding is conducted is framed under the proviso to Article 309. Now this, whatever it is, what is the status? What is the source of power? It is the
source of power is that my lord by
administrative instruction.
Source of
So if that is so, how far it can overlap or interfere with the proceeding conducted under the CCS?
It's not overlapping. It's kind of true.
But we don't know. At least for myself, I don't know unless I see what is the.
This is I can tell before the Lordship. This is a preliminary inquiry. Lordship kindly consider.
Oh.
This is nothing but a preliminary inquiry, as it happens in this case also.
No, PE happens in many cases.
After that preliminary inquiry, after having been concluded, there may be some opinion, my lord, that yes, the departmental proceeding can be started. Then this departmental proceeding in the present case, departmental proceeding started by my lord issuing so-called notice, articles of charges, and appointment
So 19/7/21, there is an opinion. That is not the opinion of the employer.
No, my lord. It's not the opinion.
Just have a look at your list of dates. 19/7/21 is not the opinion of the employer.
No. This is not the opinion of the employer.
Therefore, we are saying under CCS, somebody other than the employer, whether he can do so, what is the legitimacy that I would like to see. Where is the manual? Please show.
It is not CCA rules, sir.
CCA rules is clear, that we have seen. That is very much akin to the CCA rules.
So that's not only
I can produce the same before your lordship. Within 2 or 3 days, I have already.
Let us have the benefit.
Yes, the only thing, my lord, is this, my lord. I'm not saying whatever my learned senior friend has said, my lord. Let that be any adjourned date. My lord, 28th is the next date. My lord, 28th of November is the date, my lord, when I appear before the inquiring officer. I have papers to show, my lord. So, my lord, your lordship initially granted me an interim order.
No.
Initially, your lordship asked. Your lordship can take up order dated 24/9, wherein your lordship was granted stay till 21st of November. 14th was the date when the.
Let him come for a few days more.
This is the
So also it fell from your lordship
now
that non-supply of documents.
No,
to
see
the
the,
delinquent officer, whether inquiring authority can say that that proceedings be dropped.
no, there are
Because-
two aspects. One is what is the role of these persons under this manual? Unless we see the manual, we are not in a position to form any opinion on that basis. The other thing is, the law is very well settled that once a proceeding is dropped, then it cannot be just because it is not to the liking of the disciplinary authority, he cannot say that I will do it again. Then the issue which will arise for you here, there is no finding.
Yes, yes.
It is kind of a lapse.
No, yes,
It
my lord,
is not a finding. So we'll consider that, but let him come with that document.
My humble submission, my lord, as I go through, my lord, one or two judgments, that the inquiring authority, he has to come to a conclusion that
Correct.
the charges are proved or not.
Not proved. If
But
once he says not proved,
Not proved,
then
the
the law is clear that you cannot ask for again.
No, but the opinion, my lord, may I tell? But the disciplinary authority may accept that opinion, may not. Lordship kindly consider.
May not, may direct for further also.
Yes, then my lord, the second so cause and my lord given opportunity of hearing. Again.
May direct
Then
for
again-
further also, but no de novo. That is the law.
Yes.
Yes.
But here the seeing is this, that because of non-supply of documents, he said that proceeding.
But this is all because of this authority.
Yes.
Now, what is the status of this authority? That's why I want to see that manual.
No, yes, my
It
lord.
is because this authority who has conducted a PE and then he is giving the opinion, how he is an authority under the CCS.
But
What is the-
one thing, Lordship, may I tell one thing? One thing, my lord. Yes, what fell from Lordship, I have, my lord, I am my lord, duty bound to answer. But one thing, my Lordship, kindly consider, so far that preliminary inquiry is concerned, only that thing, my lord, recommendation. Then after recommendation is that departmental proceeding may be started. Now, in terms of Rule 10, in my lord, and in the my lord, this
Under
so-called
Rule
it is mentioned there.
So therefore, Mr. Sen, at this stage, what we want to know is under Rule 10, who is this authority
Under Rule 10,
to give such an opinion?
under Rule 10,
Under Rule 10, it is the disciplinary authority.
under Rule 10 disciplinary authority.
Then
No
from
doubt.
where he is giving an opinion?
Now, madam, may I tell, the disciplinary authority, if he thinks and feels that it is that the departmental proceeding be started. The
That-
question, now, madam, may I?
There can be no dispute.
Now, the question is whether
See, when you say PE, then normally PE, when a PE is conducted, when the disciplinary authority finds a reason for a preliminary inquiry, he asks someone to conduct a preliminary inquiry, then he forms an opinion whether a charge memo is to be issued or not.
follow.
Here, there is some authority other than the disciplinary authority. He gives a letter saying that you please proceed against him.
Now, proceed against him following all by lord the
We
rules.
don't know, I don't know.
Following
We
all-
want to see how, whether he has the authority to give such an opinion.
my lord, under that, my lord, I think, my lord, I shall place under that, because of this purpose.
And
it was-
plus,
it
since
was
you are
set up.
saying it is of 65, there may be some judgment dealing with this issue.
91 judges.
How they are to reconcile their scope and jurisdiction.
Normally, what happens in vigilance, my lord, I may say, I'm not saying this. Once matter will be soon heard by your lordship. There, the vigilance gives the charge memo, everything, the name, who will be the inquiring authority, who will be the presenting officer, everything is sent to the authorities with a caution. Just don't disclose it to the incumbent concern, and thereafter the authorities, a 2-page memorandum is issued without any sign or signature, and my lord, I have been charged. My lord, charge memo has been served.
Here it
It
is.
says, here I may not know, I do not know. My lord, in that
Here it
case,
is
it's there.
not. So I do not
My lord,
know
there
where
is a
it is.
judgment of
Here,
1991
my
which
lord,
says
it appears
the
from
CVC or the finance ministry has nothing to do with vigilance inquiry. It's only about the disciplinary
the,
authority.
here it appears from the charges.
No, but
mentioned
there are guidelines issued by the Union of India from time to time to regulate
Yes, my
how
lord.
it will overlap and which will prevail at which circumstance. We have seen in many cases. Here we don't know. At least for myself, I don't know. You may be knowing, but I would also like to know.
The vigilance manual, my lord, is not available in the market. My lord, I have searched.
No,
for
Mr. Kalol Basu handed over some document in the other case, but he also did not have the manual.
only
So-
my lord, state can provide. My lord, it's
I shall,
kept secret with them.
I have already, my lord, made the requisition, but I think, my lord, it will be, my lord, with me. Lordship, kindly, my lord, take it in the next Monday.
Which manual? What is the name? Do you know the name also?
The state initially it was West Bengal Vigilance Commission in 1965. Then in 2012, my lord, it is State Vigilance Commission.
the
So one thing Lordship has to, my lord, take it that whether if any preliminary inquiry is there and then eventually, my lord, culminating to any recommendation for initiation of departmental proceeding in terms of the CCA rules, then whether and the earlier inquiry that would not give any, my lord, the effect in the next actual departmental inquiry, then whether, my lord, there is any, I think, prejudice to the.
no, therefore the manual must be couched in that language. Only when we see that we will know what is the scope. Therefore, we said whether it is overlapping or it is just supplementing. Yes.
Item number 15.
We will not take it up because his lordship has a bench at 110. So there's no point in taking it up for 5 minutes.
Original side matter item number 1.
For item 1, I appear for the petition appellant, writ petitioner. Now, my lord, the other side is not here. This has been specially assigned to this bench. Let for going to the papers, it's a very short matter where an unapproved teacher of a DA getting school. But kindly hear me for 1 minute. An unapproved teacher of a DA getting school. Well, a DA getting school is such a school where the teachers who are approved, whose appointments are approved by the government, used to get DA, the dearness allowance. Rest of the teachers, they don't get DA. Now the present case is, I am a teacher who is not getting DA. It's a private school. Now,
So in private school also there are teachers who are getting DA.
because my appointments, until and unless my appointment is approved by the government,
No,
I will
what
not
we
get
are
DA.
asking is that there is a particular class of teachers in private school also who get DA,
Yes,
provided they are approved.
yes, by the government.
You say you are not approved.
No, I am not approved. My approval has been turned down by the District Inspector of Schools, Kolkata. Now, why I have challenged this order of disciplinary proceeding is
Challenge initiation of a disciplinary proceeding.
yes, which has been initiated against me by the school management on the ground that the school management has invoked the disciplinary rules of 2018, which is meant for the teachers of a government aided school. My school is not a government aided school. Now, in that writ petition, that is a moot question. Now, the disciplinary proceeding was continuing. I questioned the disciplinary proceeding. The honorable single judge was not pleased to grant an interim order. Interference, questioning which I have come to this court division bench.
Interim order has been rejected.
No, we prayed for early hearing and seeking an interim order. Now, as the same has not been during the vacation bench has not been passed, I approached the division bench. The division bench is also opinion that you have to go to the regular bench. Now, before the regular bench, one of the honorable judge who passed the order impugned was sitting with Justice Sababrata Chakraborty, Justice Partho Sharathi Chatterjee. That is why it has been released from that bench and it has been assigned to my lord's bench.
No, what is the order today before us? Rejection of an interim order.
Rejection of an interim order. Well, not in that sense, but because what I am on is before the single bench, the writ petition is being heard. So I do not want to praise the appeal because my main concern is before the single bench.
So the appeal is infructuous.
Technically.
Yes, take down. The learned.
প্রতিষ্ঠানের কোনো হিস্ট্রি নেই।
Item number 15,
This one.
All the marks, my lord, and then edit the marks obtained by the and then the 5 marks. And the they have added 5 marks. Then let us see this table. Page 19. Then 25. 5 marks for house dash.
Yes, he was relying on the judgment.
Have given the judgment.
Three paragraphs.
Please sit down. Yes. So what term has, see, this is a judgment that the rules of the game cannot be changed. Which rule has been changed?
I say this, my lord, that at the outset, if they had rejected my claim, I would have got a separate cause of action to altogether come before the tribunal. Now, my lord, the reply of the RTI, if your lordships may kindly see, it has been very clearly stated that I have got 69.5 as academics, 5 marks as experience, and interview 6. If the totaling is done, that comes to 80.5.
We are
I
asking
am
you
correct on that.
what rule has been changed.
Yes. Now, my lord, what they have
We are
done.
not asking you RTI reply. When you are relying on Tej Prakash Pathak to submit that the rules of the game cannot be changed during the recruitment, which rule has been changed by which you are prejudiced?
Yes. Now, my lord, what they have done, that the 163rd resolution, it has altered. It has altered by the means that they have taken both the marks of
Not
the
163rd, 162nd.
in the order it's 163rd, but their placed is 163rd.
You clarified that it is 162nd yesterday. Yes.
The documents were submitted.
Yes.
162nd, I stand corrected, your lordships. So the 162nd, it has come to a findings, or it has formulated a principle that both the marks is to be added. Now, my lord, it was not in the advertisement published. Now, my lord, the advertisement very clearly stated that the qualification is BHMS for the separate marks in experience and separate marks in the interview. But this arbitrary introduction of
the advertisement said how to calculate the marks.
No, the advertisement said so, but the advertisement did not say that for the BHMS and DHMS you will do that.
No, no. Therefore, we are saying how it has prejudiced you. That is what we are asking you. Whether it has prejudiced you or it has allowed you to participate.
I say this, my lord, that it has to some extent, yes. Because of the decision which they have taken, they have clubbed and they have allowed. Now, my lord, once they have allowed, then how this marks is being done, well, they cannot suo moto do something which is not present in the advertisement.
That is, see, that is a different thing. There are two different things.
Well, there are two aspects in this.
One is the change you have derived benefit from that change. The second is the calculation of marks.
Yes.
So we are first asking you which rule has been changed to your detriment. In fact, no rule has been changed to your detriment. If they had not introduced that, taken that decision in the 162nd minutes meeting, you would have been out.
I would have been out outright. There is no doubt, and I am not disputing that. But once
not you would have been, you were out.
Yes, my lord.
Because as per the advertisement, you were out. You were not eligible.
Absolutely, my lord. My lord,
You have gained an advantage by virtue of 162.
But there is no doubt about it, my
Now the other aspect is calculation.
the calculation of the marks. Now, my lord, lordships may kindly see is that what they have repeatedly stated and what has been their stand altogether, that this the 69.5, the marks which have been given to me is inclusive of the experience. But my lord, the RTI clearly shows that the academic score is 69.5 irrespective of the interview. Now in interview, I have got 6 and in experience, I have got 5.
No. It is not irrespective of interview. 69.5 includes, where is that RTI?
Page 32.
RTI response.
32 is the part of the reasoned order which has been annexed there to.
Where is the RTI response?
Yes. Page 27. Lordships may kindly sees, they have given me the interview marks as 6, experience marks 5, academic score 69.5. Now, if all these are added together, it comes to, my lord, 80.05. Now, the shortage of 5 marks is only because happening They have not given me the
Where
marks.
is your marks? Which page?
On page 27 of the writ petition, my lord. Page 27. Lordship, it adds up to 80.05.
From where do you get 80 points?
Yes, my lord, the interview marks is 6 on the right hand side column.
Yes.
And after that, the experience marks is 5.
Yes.
And the academic score is 69.5.
Where is 69.5?
The third column from the top on the right hand side of page 27.
Page 27.
27 is something else.
Writ petition, my lord.
Yes.
Lordship. Interview marks is experience marks is 5 and academic score is 69.5. Now, my lord, if these three are added all together, it comes to 80.05. Now, my lord, it has been their repeated stands altogether before the tribunal that the 69.5 which they are showing is inclusive of the experience.
Yes, that they have explained by the reason order how it includes.
No, my lord.
Because you got 65 on your qualification and 5 from which 0.5 was deducted because you had taken a supplement and it came to 16. That they have explained. There's no variance.
No, my lord, this 60.5.
Yes.
My lord, it should.
Very well, that we have understood.
That is the correct one because the 65 which they are again showing the variance.
Yes.
Now, my lord, I say this variance was also not initially in the
Variance.
the addition of marks which they have done, the adding of the BHMS and DHMS. My lord, it was not there. My lord,
Again, you are running in circles.
my lord, it was not
Running in circles will not help you. You have derived benefit from that decision. Just now you have admitted that you have derived a benefit from that decision. Now you are again trying to make that as a ground to assail this calculation. How can you do both? You can blow hot and cold.
No, I cannot.
Then?
I cannot, my lord. But kindly seize, my lord, one more thing is there.
So there are two different things. One is whether the change was to your detriment or to your disadvantage, whether you can be aggrieved by the change. You cannot. You have benefited from that change. The second is calculation. Now again you are trying to intermingle the two.
Well, the
Cannot be.
Well, the calculation which they have done.
That we have understood.
Well,
You want that this should be added and you should be given 80.
80.05.
There is no 80, there is no representation that you have got 80 by any document. You are saying it has to be added. They have explained in the reasoned order how 69.5 is.
Well,
It is very clear.
This is the 69.05 which they are
Not 05, 69.5.
9.5.
0.5 and 05 are at great variance.
69.5. My lord.
Yes.
I'm wrong, my lord. 69.5. Now, kindly sees that the marks calculation, the distribution of marks which has been done by them.
So RTI response is sacrosanct.
But it is their officer who has
RTI response is sacrosanct. Just shows any law.
Well, this is the RTI is.
You are arguing before us. Please, this is not done. Yes.
Lordship. Sorry, my lord. I say, my lord, the marks distribution. Well, the BHMS and the DHMS which they have done, but that is to be corrected, my lord, because
you have a briefing here with your client, then we'll hear you. Matter is adjourned for the day. Call the next Monday. Yes, matter is adjourned for the day.
Monday, my lord.
Yes.
He's taking a first part of.
Please, it is over. Call the next case.
Item number 16.
1st December.
And tell your client this is not the conference chamber of the lawyer.
I apologize, my lord.
We are asking you to tell him. Yes,
sir,
call the
I'm
next
definitely,
case.
my lord.
Yes.
Sir, I'm extremely sorry, my lord.
You should not be. You should not be. Tell him.
Such a manner. Lord, I tender my unconditional.
Item number 16.
That a charge sheet was issued. This appeal arises out of an order passed by the Honorable Single Bench, wherein the writ petitioner has assailed the order of the disciplinary authority as well as the appellate authority, whereby and whereunder the delinquent employee in the appellant before your lordship has been dismissed for service, making a clear discrimination between the two delinquent employees charged under a common charge sheet. There are two employees. If my lord may kindly takes into consideration the charge sheet once. At page 26.
Yes, what is the infirmity in the single judge order? Let us see.
Yes, my lord may kindly the charge sheet once. I will take.
No, come to the order. What is the infirmity? Which finding is not sustained?
If my lord may kindly comes to the order of the honorable single judge at page 112.
112.
112.
What is the date of the order?
4th August 2023. This is the order passed by the Honorable Single Bench, whereupon the appeal has been preferred before your lordship.
We are referring at page 140.
140. That is, yes, the same, all the same. But that was the order annexed with the memorandum of appeal that I have annexed. Your lordship can also take into consideration the page 112, that is same order. If my lord may kindly considers, but two things I will place before your lordship. First, the disproportionate punishment has been meted out. Two delinquent employees were charge sheeted by a common self-same evidences, common disciplinary proceedings. One was demoted in the post, reduced in the rank, and the delinquent employee before your lordship was dismissed from service. But that point was sought to be agitated before the appellate authority under the provisions of the appeal. But the specific ground was taken. That was not been, specific finding has not been fined by the first appellate authority, and hence the writ petition was filed. But the other point is that the two charges are interlinked. The first charge being the substantive charge, in which both the delinquent employee has been found not guilty. Based on the second charge, which I will submit as a duplicity of the first charge. On this basis, the delinquent employee both has been found guilty, and on the basis, my lord, one has been reduced in the rank, and the appellant before lordship has been dismissed of service. Third is that, my lord, the acceptance of the guilt of the petitioner is not voluntary. It is under coercion, undue influence, and threat that the delinquent employee has been made to submit before the recording officer, that is prior to issuance of the charge sheet, as well as before the summary security force court, that is the disciplinary authority. And fourth point, but the informant on the basis of which the charge sheet was drawn, that informant person was never produced as a prosecution witness. If my lord may kindly turns to page 112, may I place the order? May I, my lord?
Just a moment. We are going through the.
Let me take a note.
Where is the finding of the inquiry officer?
My lord. My lord, may kindly turns to the page 61 and 62. Verdict, and thereafter 62, 63 is the sentence. Finding is in this way, my lord. Verdict of the court, 61.
So where is the BSF Act and this is under which provision?
This has been passed, my lord, by the disciplinary authority without assigning any reason whereof only the verdict of the court has been given.
We are asking you, it is conducted under which provision? Why don't you listen to what we are asking you?
My lord, the provision would kindly come to chapter 7, page 56, the charge sheet, hearing of the enrolled, and thereafter the findings are to be given. It has been given.
Page 56.
Page 56 of the BSF rules. Chapter 7, charge sheet is issued under Rule 44. Thereafter, hearing been given under Rule 45. Commencement of trial under Rule 66. Sentence is given under Rule 102. Rule 102 of the BSF rules.
You are Hoshiar Singh.
Yes, I am Hoshiar Singh. There were two persons, Gani Ram and Hoshiar Singh. Hoshiar Singh is the writ petitioner appellant before your lordship.
এটা কোথায় আছে? ওটা এখানে আছে। 55 Very
Where is that statement that you have given?
Yes. If my lord may kindly turns to page 33 and 60. Page 33 is before the pre-charge sheet condition, preliminary inquiry, and page 60 is before the disciplinary authority. Page 33, my lord may kindly comes to.
No, your statement recorded before the commandant.
Before the commandant.
Where is that?
Page 33.
That is not your statement before the
My lord.
That is not before the commandant.
Before the recording officer.
We are asking you where is your...
Page 60.
Page 60.
Page 60.
What is the date? 25/6/2008.
25/6.
This cannot be. This is subsequent.
No, madam. That is before the disciplinary authority. That is summary security force court, and the recording officer under Rule 45 is at page 33. That is pre-charge sheet condition, based on which the charge sheet was issued and the disciplinary proceeding proceeded before the summary security force court as per the law in force. And this is the court which recorded the submission, which is apropos to the evidence given at the pre-trial stage. Kindly see, my lord, the evidence may I read out.
What is the date of the charge sheet?
Charge sheet date. Charge sheet, page 26. My lord, the same date, 25/6/2008.
25/6/2008.
And the pre-charge sheet, page 33.
Where is the charge sheet?
Charge sheet at page 26.
That is not 25/6/2008. That is 8/5/2008. You have got all your dates wrong. It is of 8/5/2008.
The charge sheet?
Yes.
No, below the charge sheet it is given 17 May 2006. The court signed it on 25th.
No, above that. Signed 8/5/2008.
8 May 2008. Thereafter another signature has been given, that is written 17th. My lord.
You have got all your dates wrong.
18th May. 8th May 2008.
We are asking you where is the statement recorded before the commandant.
Well, the commandant is the man of the statement. Two statement has been recorded at page 33. This is the recording officer who has recorded, who have been appointed by the
statement that you are reading from page 33 is recorded in the proceeding.
15th of February 2008 and the charge sheet of 8th May 2008. Kindly see the signature on page 33 left hand side.
Yes.
A.C. Chowdhury, independent witness, recording officer, as well as Hoshiar Singh, the appellant before your lordship. Date is 15th of February 2008. Thereafter, the charge sheet was filed on 8th of May 2008. So it is a pre-charge sheet condition.
A statement of accused. How can you be accused before the charge sheet?
That they have recorded in this way, madam.
Cannot be. There is something amiss.
Madam, may kindly see the statement of the accused that they have recorded in this way. I have not been accused at the alleged accused. It could have been alleged accused. Now the same before the summary security force court, my lord, it was recorded on 25th of June 2008. That is after charge sheet. Kindly see the evidence, my lord, once. May I place it, my lord? Before the recording officer.
Where is that statement that you say has been recorded under duress?
My lord, may I read out? May I read out?
Where is that statement?
Yes. Kindly see, my lord. May I read out the statement?
Where is it? Which page?
Page 33. 33 and 60. 33 is pre-charge sheet and 60 is the before the disciplinary authority.
Please read 33.
Yes, ma'am. My AOR of ambush was checked and there was no crossing of cattle. There was an allegation that I have alleged help in cattle.
Please read.
Through my AOR, I neither heard any noise nor knew anything while I performed ambush duty. H.C. Ganiram, the co-accused, and C.P. Surendra Singh are from the same district state. H.C. Dharmender and H.C. Sunil Kumar told me at BOP Chandra Chagdani to accept permitting line of 1 or 2 pair of cattle and assured for lesser punishment. He told me that the money deducted on punishment would be compensated by giving me double money. CHM told me that if I do not agree to them, he would trap me and somewhere else and I would be sent home. I got scared This is the whole that is why being interviewed by the commandant, I accepted a permitting line. They had also told me that if I accept permitting line, Ganiram would be saved.
Now, next line you read cautiously.
My only mistake is that I accepted permitting line in front of the commandant because of
In
fear.
front of the commandant. So where is this?
But this is the recording that what recording has been made with the commandant, that may not be before me. But this has been recorded in the pre-charge sheet stage. Apart from that, if any statement has been made by the commandant, that they can produce, but the respondent can produce. This is
You are annexing a copy where this is your statement and you are asking them to produce.
I have said I only made because that may be your.
I accepted permitting line in front of the commandant because of fear. So you accept that you have accepted, but you are trying to explain it.
I kindly consider.
You are accepting that you have made the statement, but you said I have made it out of fear.
Yes,
so where have you made that statement? And you are saying they have to produce it. Wonderful.
No. Kindly see, I made.
Read as many times as you want. The meaning will remain the same.
My only mistake that I accepted permitting line in
front of the commandant. But out of fear. So you don't deny that you made the statement. You say it was out of fear.
It was.
So when did you? We are asking you. Say they have to tell us.
No.
Very wonderful.
My lord, apart from this evidence, my lord.
Not apart from. First, explain what we want to know. You are here to satisfy us. You can keep arguing all day.
My lord, may kindly see the hearing officer was appointed by a
So that is the statement that you have said it was obtained under duress.
Yes, before the summary security force code, I have stated. Kindly come to page 61. Page 60. That is before the discipline authority. Third paragraph. On 11 November.
Let us read. Let us read.
Yes. This point was raised before the Honorable Single Judge, which was not been returned with any finding. That was been raised before the Honorable Single Judge. Paragraph 8, my submission has been recorded.
Raise your appeal.
Title appeal, page 74. My lord, I have raised this specific point. Paragraph 9, page 68. Page 68, paragraph 9. Page 68. Paragraph 9. No finding was arrived at by the first appellate authority. And the point was raised before the Honorable Single Judge. Paragraph 9(8) of the impugned order. Same point I have agitated, but that was not returned with any finding. Ganiram's name was also taken before the first appellate authority. He is the co-accused. That I have been pressurized by the Ganiram, and the other person to save Ganiram, my lord, forced me to accept the guilt. That was not an voluntary confession, either before the pre-trial stage or before the summary security force court. And the appellate authority has never made any findings to that effect.
Yes.
My lord, may kindly takes into consideration the provisions of the Contract Act, section 14 to 80. I have placed the kindly consider section 13 of the Contract Act. (13, 14 to up to 18).
This is under which provision rule? For which rule? This summary force court is conducted under which rule? Summary security force court under which rule? SSFC.
Yes, my lord may kindly takes into the formation of the court. Your lordship will get at section 48 is the punishment to be given by a summary security force court, and the proceedings to be held Rule 65. Section 48 read with Rule 65.
Where is it? You got only one. It's not a conclusion, it's a statement. That material. So whether the conviction or your, when they have held the charges proved, it is on the basis of your confession or it is because others have also supported the allegation?
My lord, so far as the order to be been given, this is the order of the verdict of the court at SFC,
Page?
page 61 and 62. And my lord may kindly consider 61 and 62 and 65. So far as 61 is considered, that is the verdict of the court holding both the delinquent employee as not guilty of first charge and guilty of second charge. Second charge in my submission, my lord, it will be duplicity of the first charge. The first charge is the substantive charge. In the substantive charge, I will place the charge sheet, my lord. The substantive.
You are repeating the same thing again and again. You are not responding to the court's query. That is the whole problem. We are asking you that you said that the confession was recorded under duress.
Yes,
Whether the finding that charges has been proved is recorded only on your confession or it is after taking into consideration any witness? How many times you will submit that the second charge is repetition of the first charge? Once the first charge is not held proved, second charge cannot be held proved.
My lord, so far as the prosecution witness is concerned, my lord, 9 prosecution witness adduced evidences.
Oh, you cross-examined them.
But I didn't cross-examine all, but the but the evidence of the PW1 and PW2, it says that the entire information has been derived by some other persons who has not been produced as a prosecution
You
witness.
cross-examine any of the witnesses?
Yes, I have the occasion.
Which witness you have cross-examined? Tell us, show us from the record. Where is that averment in your writ petition that you cross-examined the witness? Where is that averment in your appeal that you cross-examined the witness?
Yes,
there is no such averment. You have not cross-examined a single witness.
No, there was no specific cross-examination on the point.
Then why you say that you have cross-examined, sir?
Only few questions were pushed.
You have not cross-examined them at all.
1 or 2 minimal questions.
Show us one question. Don't make such submissions contrary to record. It's not not at all appreciated. Confine yourself to the records.
I have cross-examined one person.
So 9 prosecution witnesses.
Comes to page 45.
9 prosecution witnesses.
9 prosecution witnesses.
Yes.
All have reiterated what PW1 and PW2
We
have
did
said.
not ask you that. We asked you whether you have cross-examined or not. You have not cross-examined.
My lord, only.
Then we did not ask you what is the credibility of their statement. We did not ask you what they have said.
Only cross-examination has been made so far as PW4 is concerned. At page 45. PW4 is one Om Singh. I have cross-examined him.
You have not cross-examined anyone. Not a single witness. Apart from 9 witnesses, who were the other persons who deposed?
My lord, so no, there is no defense witnesses. Only 6% witness before the recording officer prior to charge sheet, and 9% adduced as evidence before the.
So 6 prior to charge sheet and 9 subsequent to charge sheet in the proceeding.
In the proceedings. Only PW1 and PW2, my lord, I will be, my lord, bringing to your lordship's knowledge.
No. You are not arguing an appeal. We are not going to look into. We are not going to look into.
No, I am not on that. I am not calling your lordship to.
You are asking us to see what they have said. We are not going to.
I am only on perversity.
We don't want to see that. Perversity will not be in their statement. The perversity has to be in the finding.
May I just submit before lordship?
In the finding, not in their statement.
May I just.
No, sir. We are not going to allow you. We will say we stopped you from going into the evidence. It is not the scope. You have argued before the inquiry, you have argued in the appeal. Single judge has seen everything. Why should we go into the records of the inquiry? This is not an appeal.
So far, may I just submit before Lordship, if permits me. But so far as the evidence, I will not call you upon to look at.
You will not go into the evidence.
The informant has not been cross-examined.
That is all right. That we have seen. You have been taking this point. That informant has not been examined.
But there is a
maybe not
coordinate bench decision to that.
Show us that in every case where informant is not examined, the finding is to be discarded.
My Lord, kindly consider this decision. Volume 4, CHN, Calcutta High Court Notes, Calcutta 176. Direct to the my Lord. My Lord, may kindly comes to internal page 5. Internal page 5, second paragraph. From the aforesaid discussion, it appears that the appellant was tried in the summary security force court in clear violation of the provision of Rule 158, as an explanatory memorandum was not attached to the proceeding, which was mandatory requirement under the rule. Furthermore, a vital witness like the informant was not cross-examined in course of the trial of the appellant in the summary security force court, only to deny opportunity to the accused person, including the appellant herein, to re-examine a vital witness. From the above illegality and illegality, we are of the opinion that the impugned order of punishment cannot be sustained in the eye of law. But that was being sought to be assailed before the Honorable Apex Court, which your Lordship will get at the end of the judgment. So SLP was taken out by Union of India before the Honorable Apex Court, challenging the same finding.
Where does it say, where does it lay down the law that if informant is not examined, the proceeding is vitiated?
That in clear words said not recorded. But
that is your submission. Therefore, we asked you.
That the court has came to a finding.
The court has come to a different finding. Explanatory memorandum, which was mandatorily required, was not placed. Additionally, the informant was also not.
Yes.
So therefore, that is a different thing.
Informant.
This does not cover your submission. Yes, at which page is the finding 60?
Finding of the disciplinary authority.
No, inquiry. Yes, disciplinary.
Yes, my Lord, my kindly comes to 61, 62 and 65.
We are not clear with the procedure yet.
Finding is at 65. Order by the commandant.
Put number 4.
So what is the setup of the SSFC? How it is done? There is an inquiry officer. There is a presenting officer. Where is the procedure?
My Lord, may kindly sees chapter 6, section 64 onwards. The functioning, your lordship will get in the rules, rule 7, chapter 7.
Chapter 7 of the rule.
Chapter 7 of the rule read with chapter 6 of the act. Chapter 6 of the act, it relates to the kind of security force reports, that is general, petty and summary. The functioning, your lordship will get at chapter 7 of the rules.
Rule 43.
Rule 43 starts with thereafter the recording of the evidence, your lordship will get at page 48. It's rule 48.
Rule 48.
Rule 48. And thereafter the charge sheet, rule 53.
We'll have to examine the procedure. Will allow us to go through this. So 45 appears to be relevant. You are an enrolled person.
Yes.
So which procedure will apply? Rule 45?
My lord, 45 is the status of the person, of the delinquent employee. If he is enrolled under hearing of the charges against enrolled person. I am an employee, I am an enrolled person, but recording of the charge, recording of the evidence of the pre-trial stage will be under Rule 48. And on the basis of the recording under Rule 48, charge sheet is been filed under Chapter 8, that is Rule 53.
It is under 44. What are you saying? We will have to go through it. Take down. After
My lord, instead of 2nd December, can it be on 3rd December? Instead of 2nd December, can it, because I have a personal difficulty on 2nd.
what do you want?
2nd December, I have a personal difficulty. Can it be on 3rd December? Subject to
Oh,
revision.
then it will come on 8th. Yes, 8th.
Much-
Item number 17.
Paying for short possible or something.
Short Passover. Why? Very well, call the next. Call the next.
17 and 18. 17 and 18.
Both. Yes.
I appear item number 17.
On behalf of the,
Respondent number 1, writ petition.
you are the private respondent. Not today. 17, 18, not today.
19.
Come on Monday then.
Monday.
Twenty.
20 will drive for the appellant. ट्वेंटी डाकले तो 20. 20. Page 85 is the order. Order under appeal.
আর দেখাচ্ছি না তো। আসলে ওই অর্ডারটা দেখাচ্ছি না, এবার ডাইরেক্ট দিয়ে দিই।
What is what? Indian water.
Mm-hmm.
You're the husband? Yes.
Well, first thing, but I am only harping on 2 points. Well, the other side is my writ petitioner is the daughter of the appellant. Initially, my lord, not made a party. My lord, I filed an application of addition of party and it was allowed. Matter came, this order was passed, appeal in the appeal court, my lord, the matter sent to the mediation. But I tell you, lordship, my lord, I am not against my daughter. She is entitled to get what is she is entitled to get. Is the employer, my lord, today, my lord, she is not represented. But only thing, my lord, it bothers the case that petitioner is entitled, my lord, appellant is entitled to get monthly family pension full. And the nominee is only the mother and daughter of the deceased employee. Kindly have a look. On my lord, 4th July 2024, matter sent for division, mediation.
So there is mediation has failed.
Mediation has failed.
So mediation now is over.
Yes. But I will restrict my submission only about my right. I am not against my daughter. First thing, my lord, who is entitled to get family pension? The definitions. Died in harness, my wife died in harness. Admittedly, my lord, daughter will entitled to get PF, gratuity, share, everything. But family pension will be payable to the husband. This is the only case before your lordship. My lord, unfortunately, I am the single bench. My lord, the respondent number 6 added respondents are not able to apprise before the single bench. That is the whole thing, my lord. And I have been represented at all. So the Larnavida proceeded on the basis that
You were not represented.
Yes. First line, despite service of my added respondent Raju De is the appellant before your lordship.
So you did not appear. It's not that you were not added.
But
you chose not to appear.
Not chose, my lord. But somehow, my lord, it was a transferred brief. The appeal was not. Now, may I, my lord, hand over the rules?
The daughter is appearing.
Daughter is today. He is not appearing.
Otherwise, she is appearing.
Otherwise, he is appearing.
Yes, respondent 2 to 5. There was somebody representing respondent.
Read petitioner is not representing.
No, writ petitioner is respondent 2 to 5 in the appeal.
No, read petitioner. Read petitioner is the respondent. Respondent 6, yes.
Respondent number 6. Respondent number 6 is represented. There was some lawyer appearing on a Mr. Ashish Kumar Chaudhary.
Yeah.
Where is he?
I am for the employer. Lordship, the issue is the entangled husband is saying he is entitled.
You have not challenged the order.
No, it's not. They are not challenging. I am also.
Therefore, you have nothing to say.
Yes.
Where is the writ petitioner?
Read petitioner is not appearing today. No?
No, she has earlier been represented. Therefore, please inform the learned advocate, Mr. Chaudhary. We'll just adjourn it, not today. Ask him to be here on Monday. Yes, not today.
But, if I may place the rules now.
Why in their absence? Let them be there.
Yes.
It is only her right which you are
Yes.
contesting.
It is also my right. It is between
Which
us.
you are contesting.
Yes.
They have agreed to whatever the court has said.
Your Lordship, kindly pass an order. I am directing. I will send a notice that if she not appear, then
Respondent number 6.